Good morning, everyone. We have a very international group today here in this webinar. Guests from Azerbaijan, of course, but also Latvia, Estonia, and Finland are here represented, so that is great. My name is Mikko Lehtonen, and I work here in Satakunta University of Applied Sciences as a research manager, and I am also part of this LEF Network Azerbaijan project that this webinar is a part of. So just shortly about this LEF Network Azerbaijan project. Our mission is to help companies from Latvia, Estonia, and Finland to do business with Azerbaijan. Our main task is organize trade missions to Baku. We have done already five different trade missions with companies from our countries to Baku, and we also bring interested companies from Azerbaijan to meet our companies here locally in Latvia, Estonia, and Finland, and these kind of trips have been organized. We have the project has been running for 2 years, and we have about 1 year left in this project. But we do lots of other stuff in LEF Network Azerbaijan also, and these webinars are important part of the project. We cover different interesting topics for our companies, and today is very, very important one also. So, and shortly about our partners, we cooperate, Satakunta University of Applied Sciences cooperates with Latvian and Estonian chambers of commerces in this project. And in Azerbaijan, our main cooperation partner is Caspian Energy Club. But enough about our project. Welcome to our webinar, Legal Protection of Sale Investments in Azerbaijan. And we are cooperating in this webinar with Stannum International Training and Consulting. And shortly, this webinar will provide essential guidance on the legal frameworks governing franchising, agency agreements, and joint ventures in Azerbaijan. So really important and most likely very interesting topic for the participants. And this webinar will be recorded, and we will share it in our webpage and send the link for you also after this, and all the materials will be sent to you after this webinar. The duration is about 2 hours, and you will have a chance to ask questions and get answers at the end of this webinar. And I would like to give the floor to our expert, Mr. Emil Ketsalov, legal and compliance professional in Azerbaijan. So, Mr. Ketsalov, please, the floor is yours.
Okay, thank you. Let me share the presentation. Okay. Hello, dear participants of the webinar. Thank you for showing interest in Azerbaijan as a new possible destinations for the implementing your business projects. I hope today that today's webinar will be useful for you and will help support the development of new project and the growth of your business. Of course, I would also like to thank the organizers of this webinar for giving me the opportunity to share my experience and knowledge with you. Okay. On this slide, you can see a brief overview about me. I have more than 20 years experience in legal and compliance, being a head of the legal department of Ministry of Defense Industry, I am currently developing a new legal frameworks and regulations for the defense industry. I'm also legal counsel at the Azerbaijani Bar Association. I have a long-term experience as an in-house legal in the big holdings and companies in Azerbaijan, and as a senior legal advisor in one of the big four consulting companies. Okay, now I'm engaged with the Stanum International Training and Consulting as a legal and compliance expert. Okay. Let me provide a brief information about the Stanum International Training and Consulting, and it's a globally recognized leader in professional training and consulting, which is approved by a British Chartered Institute of Procurement and Supply, and the strategic partner of the British Chartered Institute of Logistics and Transport. Okay, about today's topics. Today we'll be discussing some very interesting topics, which can be divided into two main parts. First is specific of the legal regulations of franchise engines and agency agreements, and the second part is the legal framework for business cooperation and partnership in Azerbaijan. Let's start with the franchising agreement in Azerbaijan and we'll talk about the normative regulations of franchising. So the fundamental provisions governing the concept of the franchising set out in Chapter 35 of the Civil Code of Azerbaijan. However, this chapter doesn't encompass all the necessary rules and regulations governing every aspect of the legal relationships between the parties to the franchise agreement. Depending on the subject matter of the franchising agreement, the Civil Code of Azerbaijan establishes a system of references to the legal provisions governing the relationships between the parties to such agreements. So, according to the Article 731 of the Civil Code of Azerbaijan, if the subject of franchise agreement involves the granting of rights to use intellectual property, we shall apply to the provisions of legislations on copyrights and related rights, as well as patent law. If the franchisee is primarily engaged in the distribution of the franchisor's goods, the provisions of the Civil Code on commercial representation and concession agreements shall also apply. And if the parties assume additional obligations under the franchise agreement, such as a sale or and purchase, lease properties, contracting or service provisions, we shall all apply respective provisions of the Civil Code governing this type of contract. So, as we understand, everything depends on the subject of the franchising agreement, and everything's depend on relationship between the franchisor and franchisee. And given this regulatory framework characterized by absence of the comprehensive legal acts governing all aspects of franchising, as well as a continuous development and modifications of the franchising relationships, it's essential for the parties to such agreement to apply not only the mandatory legal provisions, but also the principle of the freedom of contract in regulating their relations. But these conditions that they do not contradict public policy and mandatory legal provisions, of course. On the slide, you can see links to the English version of the Civil Code of Azerbaijan. You can use it. But of course, I must point out that this is not official translation, and some provisions of the legal acts may have been amended. Of course. Okay, the franchise relationships in Azerbaijan are generally structured under the license agreement and commercial contracts, drawing legal principles from the civil code, as you see on the slide, law on trademarks and geographical indications, competition code, and law on commercial secret. The civil code governs contractual obligations, license, and business arrangements. The code also provides general principles of commercial agreements, including the good fair dealing, and liability, of course, and regulates issues such as termination, exclusivity, and dispute resolution. The next act is the law of trademarks and geographical indication, which protects intellectual property rights of franchisors, defines the requirements of trademark registration with the intellectual property of Agency of Azerbaijan. The competition codes prevents anti-competitive clause in franchise agreement, addresses concerns related to the market dominance and restrictive trade practice. Law on commercial secret defines the understanding of confidential information and governs the condition of operating. And we changed our topic and transfer to the normative regulation of the agency agreement, and then let's talk about it, and then we came back to the franchising agreement. The fundamental provisions governing of the agency agreement in our code is called the Trade Representation Agreement, specified in chapters 42 of Civil Code of Azerbaijan. The Civil Code of Azerbaijan set out and regulates the fundamental terms and of commercial representation agreement, such we will now examine in greater detail. So the key legal provisions affecting agency agreements is following. The Civil Code of Azerbaijan, as in the franchising agreement, law on competition, and now it's called the Competition Code, and law on commercial secret. In the frame of the agency agreement, the regulations, Civil Code defines the legal relationship between the agent and principals, specifies the agent's authority, including the exclusive and non-exclusive agency arrangements, and regulates commission rights, obligation, and termination procedures. Competition Code limits anti-competitive practice in agency contracts as well as in franchise agreements, prevents abuse of dominance in agency distribution network. And law on commercial secrets, of course, protects competition information disclosed to agents and allows the inclusions of non-disclosure agreements, NDAs, in agency contracts. Okay, let's turn back to the franchise agreement in Azerbaijan and define the definition and key features of the franchising in Azerbaijan. So, pursuant to Article 722 of the Civil Code of Azerbaijan, the franchise agreement is defined as a long-term contractual relationship in which the independent enterprises mutually undertake to facilitate the production, sale of goods, or provision of services by the fulfilling specific obligation as necessary. it is evident that this statutory definition does not fully capture the comprehensive nature of the franchising concept and doesn't define outlines its key characteristics. In practice, however, franchising is governed not only by the provisions of civil code, but also by other local regulatory acts that may apply to various legal relationships arising in the context of franchising. Additionally, business practice and foreign legal experience may be taken into account, provided they not conflict with the mandatory norms of Azerbaijani legislation, of course. Okay, franchise agreements in Azerbaijan combine elements of multiple contractual relationships, such as intellectual property licensing, trademarks, patents, copyrights, and trade secrets, commercial representations, if some franchisee primarily distributes the franchisor's goods, lease agreements if the premises of the equipment or equipment are leased to the franchisee, and service agreements if the operational support, consulting, or training is included. The principle of the contractual freedom allows the franchisors and franchisees to define specific term provided to they do not contradict mandatory legal provisions. Okay. Also registration and disclosure requirements. In accordance to the Civil Code of Azerbaijan, a franchise agreement must be concluded in the simple written form. Actually, the Civil Code doesn't require any additional certification or notarization of the contract. However, considering that franchising involves the transfer of the right to use trademarks, which are protected intellectual property assets, it's necessary to refer to the legal requirements governing to the transfer of the trademark rights. According to these requirements, an agreement on transfer of the trademark rights only takes effect after the registration. Registration in the State Agency for Intellectual Property of Azerbaijan. We will discuss the registration of intellectual property rights in more detail in our next webinar, which will focus on the legal regulations of intellectual property in Azerbaijan. It's important to note that franchising relationships between the parties may be formalized through the multiple agreements, one of which is a trademark rights transfer agreement. In such case, only the trademark transfer agreement is subject of mandatory registration, but the franchising agreement may be concluded in simple form without any registration or notarization. Based on my legal practice, I have encountered instances where these multiple agreements were used in franchising agreement. In my practice, I divide the packet as the documents regulated the franchising relationship between the parties to the different agreements. The main agreements was the franchising agreement, and the transfer of legal trademark rights was regulated by the additional agreement. Okay, let's talk about the key terms of franchising agreement. A franchise agreement in Azerbaijan should clearly define the right, obligation, and financial arrangements between the franchisor and the franchisee. On the slide, you may see the main terms They're typically included in a franchise agreement. It's, as you know, general provisions, intellectual property rights, financial terms, franchisees' rights and franchisees and franchisor rights and obligations, term renewal and termination, and very important, the territorial rights and exclusivity, and of course dispute resolution and government law. Okay, general provisions. It's a general clause regarding to the parties, identification of the franchises, right owner and franchisee, like a business operator. So, in general provision include specifies the purpose of agreement, of course, granting of the franchisee rights and to use the franchisor business model, brand, and intellectual property. Okay, and intellectual property rights consist of the scope of the IP rights, the franchisor's rights to use the franchisor's trademarks and patents, copyrights and trade secrets, trademark usage, like as restrictions on how and where the franchisee can use the franchisor's brand name, logo, and marketing material. So the next one, the protection of confidential information, obligation to prevent unauthorized disclosure or misuse of business know-how and trade secret. The trademark license agreement must be registered within the state of agency for the intellectual property in Azerbaijan to be legally effective. Regarding the financial terms, the financial terms defines the following kind of fees. The initial franchising fee, for example, the one-time payment for the entering to the franchising system, royalty payments, ongoing the payment based on revenue, fixed amounts, and other financial models, advertising and marketing fees, contributions to the brand promotion activities, and operation fees, payment for training, support, and supply of goods. Of course, these conditions of the financial conditions and terms may be changed, and it depends on the agreement between the parties and the peculiarity of the franchising subject. Regarding the franchisee rights and obligations, franchisees have a right to operate under the franchisee system, use the franchisor brand and business model, compliance with the franchisee standards. It's the most important obligation, and in practice we have a lot of troubles with this. The obligation to follow the franchisor's operational procedures, quality standards, and business practice. Training and staff requirements, for example, participation in trainings, programs provided by the franchisors, financial and reporting obligation. It's also very important part of the contract, because the franchisor should have tools of supervision how the franchisee obeys the rules and the terms and conditions of the contract. So, and non-competition clause may be in franchisee rights of obligations clauses. It's a restrictions to engaging in competing business during and after the contract terms. Franchisor rights and obligations consist of the grant of franchise rights, providing the franchisee with exclusive or non-exclusive rights to operate under the franchisee. Training and support, obligation to provide initial and ongoing business support, and monitoring and quality control, right to inspect and ensure the compliance with the franchise standards. As you see, the rights and obligations of the parties very correspondent. The next, the term renewal and termination as a terms and condition of franchising agreement. The duration agreement and the renewal conditions. It's also part of the franchising agreement. The term of the franchise agreement shall be determined by the parties, taking into account the demand for the relevant goods and services. Under the Civil Code of Azerbaijan, if the terms and agreements exceed 10 years, either party shall have a right to terminate the agreement by providing a 1 year's notice period required for termination. If neither party exercises these rights, and agreement shall be extended for the period of 2 years. In the event of termination of the agreement due to the expiration of its term and its initiative of the parties shall make efforts to extend the term of the agreement until the actual completion of their mutual business relations under the same or modified conditions in accordance with the principle of mutual trust. Of course, the term of the franchise agreements is closely depend on the parties' agreement and the specific of the subject of the franchising agreement. The terms of termination may be defined by the parties in the mutual consents. Franchising agreements shall specify clauses on terminations. For example, grounds of terminations, the circumstances under which the agreement can be ended, such as breach of contract, non-compliance with the franchise standards. It's very important. The bankruptcy and either parties. And post-termination obligation is very important clauses in the agreement. Is a duty after contract expiration, such as cessation of the use of the trademarks and business methods, not completed obligations for the specified period, and return of the confidential materials. So we should think about not only the relationship during the agreement and after the agreement is terminated. Territorial rights and exclusivity consist of the geographical scope defines the area in which the franchisor can operate. For example, in Azerbaijan, you may define the territory of Azerbaijan Republic or the more wide region for the South Caucasus or other regions. It depends on the agreement between the parties. And restrictions on expansions, it's one of the clauses related to the territorial rights and exclusivity. It's the conditions under which the franchisee can open new location. Regarding the dispute resolutions and government law, applicable law usually is Azerbaijani law and its governments in agreement, but the parties may define the other applicable laws, for example, not Azerbaijan, but other countries. We have in the practice such cases when the parties apply to the law of the third countries. And it's very important to define the dispute resolution mechanism, which specifies whether disputes will be resolved through the negotiations, mediation or arbitration, litigation in Azerbaijan courts or other variations. And contractual remedies is defines the penalty for the breach, damages, and indemnification clauses. So, as well-structured franchise agreement protects the interests of the both parties by ensuring clearly legal and financial terms. Given Azerbaijani's multi-layered regulatory framework, business should be ensured compliance with the contract law, intellectual property law, and competition regulations to safeguard their franchising rights. Okay, the next subject is agency agreement. And before the start of the this discussion and providing information about the agency agreement, I'd like to define the distinctions between the agents and distributors in Azerbaijan. Why it's very important? Because the agency and distributor agreements is very closely and very similar, but in the same time, they have a very different method of the communication between the parties. So, since a principal can be represented by the local market either through the agent and distributor, and it's important to highlight the different legal nature of agents and distributors. Under the Azerbaijani legislation, the legal status and rights of agents and distributors differ significantly based on their contractual obligation, legal relationships with the principal and or supplier, and the applicable regulatory framework. Let's talk about the definitions and legal frameworks of these two definitions, agents and distributors. Agent count primarily by the chapters 42 of Civil Code in Azerbaijan, and agents act as intermediaries in commercial transactions. According to the Civil Code, an agent commercial representative is legally independent entity authorized to conclude the contract on behalf of and at the expense of the principal, which is maybe manufacturer, trader, or entrepreneur. Agents may be either individuals or legal entities. According to the Civil Code, defines a person who are not considered as a commercial agents. It's a persons engaged in intermediary activities or transactions on the acquisition basis. The second person operating in commodity or stock exchange. It's a different field of activity. And persons who have entered into the employment contract with the principals. So the nature of the relationship between the parties is different, and it's covered by the labor code, labor legislations. Regarding the distributors, unlike the agents, distributors operate under general contract law principles, often through the sales and supply agreement. Distributors purchase goods from the supplier and resell them at their own risk, earning the profit margins from the price differential rather than commissions. So, if we define the differences between the agents and distributors, we should define first of all the criteria of differences. For example, first, the legal status of the agent or distributors. Agents acts on behalf of principal. but the distributors acts independently as a separate contract party. The second criteria of differences or distinguishes of this part of these definitions, the ownership of goods. Agents doesn't own the goods, facilitates and transactions, but the distributors owns resells the goods in the market. Regarding the contractual relationships, typically the agency contract with a commission-based earning, but the distribution agreement based on the purchase and resale. Of course, the liabilities are different. The principal is generally liable for the agent's actions, but distributors bears full responsibility for the product sales and liability. The next regulatory requirements. The subject of the agency law and commercial representation rules under the Civil Code, but the subject of the general contract regarding the distributors subject to general contract law and trade regulations. And the last one, the intellectual property use. The agents may be authorized to use the principal trademarks for the presentation, but distributors typically granted to a license or permissions for branding under the distribution contract. The agency relationships. So as you see, the distributors and agents act in the territory of Azerbaijan Republic on behalf of the principal or principal, but they have a different nature of legal nature. So that's why I want to pay your attention and define the differences between these two definitions. So the practical and legal implementations regarding this agency and distribution agreements. Agency relationships. The agent serves as a facilitator without assuming financial risk. So this structure is often preferred when the companies seek direct market penetration without transferring ownership of the goods of intermediaries. But the distribution agreements in the distributors acts independently, assuming the commercial risk. While this provides market flexibility, it also means that the supplier has less direct control over the resale process. And exclusive and non-exclusive rights, both agents and distributors may operate under the exclusive or non-exclusive arrangements. However, exclusive agency relationships often requires additional contractual protection and compliance with the competition law. The choice between the appointing of an agreement agent or distributors in Azerbaijan depends on the business strategy and risk allocations preferences of the parties involved. If the objective is a market representation with a minimum financial exposure, the agency agreement is more suitable. But if the business seeks to outsource sales and distributions while shifting financial risks to the third parties, and distribution model is more preferable in this case. For any specific contractual structuring, businesses should seek legal guidance and ensure the compliance with Azerbaijan commercial law and sector regulation. Okay, let's talk about the obligations of principals and agents. The commercial agent is obliged to make efforts to conclude transactions on behalf of the principals and work to maximize principals' client base. Inform the principals of all orders and/or concluded contracts. Provide the principals with all relevant and necessary information. Next, the following follow the principal's reasonable instructions and obtain the principal's prior consent before the offering similar products or service, either the agent's own expense or on behalf of another principals. So additional obligation may be imposed on the commercial agents or by the agreement, including the providing regular reports on specific topics, meeting a minimum turnover quota for the order and contracts, storing and delivering the goods on behalf of the principals, as well as handling connections from the principal debtors, if necessary, and for additional remuneration, of course. The client performance guarantee may be also agreed by the parties. Actually, again, agent is only required to guarantee client performance if it's explicitly stated in writing. The guarantee applies to the specific transactions or the predefined set of transactions. The agreement specifies separate remuneration for the assuming such guarantee payable immediately after the contract is concluded. Any contrary agreements are avoided. Sorry. Regarding the basic application of principles, the principal must act in good faith towards the agents and must provide the agents with the necessary information regarding the products, services, business practice, and pricings. Inform the agent in timely manner if the expected volume of commercial transactions is significantly lower than anticipated. The next application is notify the agent within the reasonable time of the acceptance, rejections, or non-performance of the proposed commercial transactions. Pay the agreed upon the remuneration to the agent, of course. The contract may also impose additional obligation on the principals, such as granting the agent exclusive monopoly rights within a certain territory or for a specific claim base. One of the most important conditions in agency agreement is agent remuneration and commission. The agent is entitled to fixed monthly fee and/or commission-based remuneration dependent on turnover and transactions value. The remuneration is determined by contract, and if not explicitly stated, the agent is entitled to the customary remuneration for similar services as established by the business practice. In the absence of such customs, either party may apply to the court for the reasonable determination of remuneration. Remuneration may be partially or fully commission-based. So, in such cases, agents is entitled to commission for all transactions concluded with the clients previously introduced by the agents during the term of agreement or as a direct result of the agent's efforts. Transactions within the exclusive geographical area or client group where the agent has a monopoly rights. And transactions completed after the agency termination provided the results from the agent's activity during the agreement terms or shortly thereafter. If multiple agents contributed to transactions, commissions is divided proportionally based on their contribution. The agent's claims to commissions arise once the principal fulfills or becomes obliged to fulfill the contract with the third party. If the transactions fails due to circumstances beyond the principal's control, the agent is not entitled to commission but must return any received payments. Commission statements are issued quarterly and payments must be made within the 1 month after each quarter. Contractual modifications cannot extend payments deadlines beyond 6 months. The commercial agent has a right to inspect the principal's financial records to verify the commission's calculations. Okay, the next point is legal consequences of termination of agency agreement. So, according to the clause 794 of the Civil Code of Azerbaijan, if the agency agreement is concluded for the fixed term, it ends upon the expiry. If the agent continues working with the principal's implicit or explicit consent, the contract is deemed to have been identified from the start. But if the contract is identified, either party may terminate it with a prior notice, for example, 1 month during the first years, 2 months in the second years, and 3rd month prior notice if the contract exceeds 2 years. A longer notice period may be agreed but but must be equal for the both parties. Local legislation also determines the case of the termination due or extraordinary circumstances. So in such cases, either party may terminate contract immediately if the other party significantly violates contractual obligations despite of the written warnings. Unforeseen the circumstances arise that make continued contractual obligations unreasonable. Okay, the agent's rights to commissions post-contract termination. It's a peculiarity of the agency agreement, and we should pay attention on it. So, upon the termination, agents is entitled of compensation for the clients they introduced, provided the agents secured new clients or increased transactions with the existing clients. The principal continues benefiting from those clients, or provided the agents lost commissions due to contract termination. The maximum compensation is limited to 1 year's average remuneration calculated based on the past 5 years, or the full contract duration if it's shorter. If the contract is wrongfully modified or terminated by the principal, the agent may seek damages, and the compensation Compensation is not paid in the following cases. If the legal relations on the agreement have been terminated due to the fault of the trade agent, if the trade agent terminates legal regulations on the agreement or personal grounds, and if with the consent of the principal agent give its rights and obligation to the third party. In the event of the agent's death, the heirs may claim the claims for compensation. So one of the important clauses of the agent's agreement is the non-completed clauses. So non-completed clauses after termination of the agent's agreement is specified if the civil code in the civil code of Azerbaijan Republic. The agent can undertake in written form not to compete with the principal after the termination of the agency agreement. And non-competed obligations is valid only if it covers only the agent's territory, clients, and product range, or if it doesn't exceed the 2 years from the contractual terminations. So the non-competed clauses have any time and territory limitation. Okay, so let's talk about the best practice of common pitfalls. Franchising in Azerbaijan is regulated under the Civil Code of Azerbaijan and requiring compliance with the contractual law, as I said, and intellectual property regulations and competition law. So essential clauses in a franchise agreement is the following: grant of rights and scope, defines the franchising models, product, service, business format, and territorial scope, including the exclusivity or non-exclusivity. Specify permitted to use the trademark, branding, and business procedures. Defines the obligations of the franchisor and franchisee in the correct form. So franchisor provide initial and ongoing training, supply the proprietary business methods, ensure the brand's consistency. And franchisee complies the operational standards, pay franchise fee, and maintain the business regulations. Supervision tool on comply with the operational standards. Very important point. It's auditing of the franchise activity, periodical reports, requests, and etc. IP rights and registration compliance. Since the franchising involves the use of trademarks, any agreement involving IP rights must be registered with the State Agency of Intellectual Property of Azerbaijan. The fee payments and financial terms are very important, clearly defined in initial franchise fee, royalties, and market contribution. Establish penalties for the late payments or non-compliance. Confidentiality and non-compete clauses, which specifies the protection of trademark secrets, appropriately know-how and sensitive business information. Non-competitive clauses should be reasonable in durational and geographical scope and to be enforceable. The termination renewal provisions. Franchising contracts may be long-term, 5 or 10 years, with the termination rights defined under the articles of the Civil Code. Ensures the clauses to exist strategies, but back rights and post-termination obligation are well defined. And regarding the key essential clause of in the agency agreement, it says is authority and scope representations, emission payment terms, obligations of the agents and principals, termination and compensation rights. So it should be clearly defined whether the agent has a power to negotiate and conclude the contracts on behalf of the principal, and it should be specified whether the representation is exclusive or non-exclusive. In agency agreement, we should define the agent's commission structure and establish the contribution for the commissions, disputes, and adjustments. The agency agreement should specify the obligation of the parties. So the agent must act on good faith, promote business interests, and comply with the reporting. And the principal must provide all necessary information to ensure timely payments. And of course, the termination and compensation rights, it's a part of the agency agreement. If the contract is indefinite, termination requires a reasonable prior notice, 1 or 3 months based on the contract duration. Post-termination compensation may be applicable if the agent have generated a significant business for the principal. The clause of the agreement shall not contradict with the imperative norm and requirements of the local legislation. Okay, and when we talk about the agreement relationship, it's very important to define the risk mitigation strategies in agreements. For example, in franchise agreements, for the mitigation of risk in the franchising agreements, I suggest to register a franchise agreement with the intellectual property of agency to secure enforceability. Include detailed operational manuals to ensure compliance with the brand and standards. Clearly define the force majeure provisions to manage the unforeseen different events, economic downturns, regulatory change, and etc. Regularly update the contract to align with the local legislative change and international best practice. And regarding the mitigation risk and contractual mitigation risks in statutory in the agency agreement, for the mitigation of the risk of agency agreements, we should define clearly performance benchmarks to assess the agent's contributions, include audit rights for financial transparency and commissions verification, specify dispute resolutions mechanism, negotiations, arbitrations, or litigation. And the last one, avoid the broad indemnity clauses that shift excessive liability to one party. So it's suggested before signing agreement to conduct through the due diligence before the signing agreements, and as I said, register trademarks and IP rights before the granting the franchises or appointing the agent. Define the clear exit strategies in contract to prevent legal disputes. Ensure the compliance with the competitive law to avoid regulatory penalties, and seek legal advice to tailor agreements to Azerbaijan legal standards. So we finished our first part of webinar regarding the franchise and agency agreement. So if you have any question regarding this topic, regarding these subjects, feel free to apply, feel free to ask, and we may discuss something regarding the franchising and agency agreement. You may also collect your questions and ask as a final part of our webinar, or after the webinar, we may apply to me and in written form via email, send to the organizers the questions regarding the subjects of today's webinar. So, as I understand now, we have not any questions, and we may continue and start the second part of our webinar, which regarding the business partnership and joint venture in Azerbaijan. Okay. In Azerbaijan, business can form partnership and joint ventures through the variation legal structures defined under the Civil Code of Azerbaijan, law on investment activity, and other legal acts. The structure depends on the factors such as liability, tax implementation, regulatory compliance, and operational control. Okay. The business partnership in Azerbaijan is formed like a general partnership. In Azerbaijani, it's called Tam Ortaklığı. According to Azerbaijan legislation, partnership may be in two forms: the general partnership and limited partnership. The general partnership is a business entity where two or more individuals or legal entities jointly conduct the business operations and share unlimited liability for obligations. The key features of the general partnership is that the general partnership is governed by the Civil Code, especially in Article from the 69 to 81. And the second key features is that each party is personally liable for the debt and obligation. It's very important because it's the distinguished part of the liability. For example, in general partnership, the personal liability is total, and in limited partnership is limited. The profits and losses are distributed based on the partnership agreement, and a person may be a participant in only one general partnership. In general partnership, there's no any limitation, minimum capital requirements, but it requires to state registration with the tax state services in Ministry of Economy of Azerbaijan. The general partnership best for the small businesses which high trust among the partners who wants flexibility but accept unlimited liability. Limited partnership LP consists of at least of one general partner with the unlimited liability, and one or more limited partners with the liability restricted or their contributions. So the general partners manage a business and bear full liability. Limited partners contribute capital but do not participate in management or conduct of the affairs of the limited partnership, nor to act on behalf except by the virtue or power of attorney. They are not permitted to challenge the actions of the general partner in managing or conducting partnership affairs. A limited partnership requires a state registration as well as a general partnership in compliance with the tax regulations. The limited partnership is the best for the investors who want to fund the business without direct financial involvement or high liability exposure. Okay, the next subject is a joint venture. In Azerbaijan, a joint venture is a business collaboration between two or more entities, local or foreign, to undertake a specific project or a long-term partnership. And the joint ventures in Azerbaijan can be structured through the contractual agreement or incorporated as legal entity. Okay. Contractual joint venture. A contractual joint venture is formed through the cooperation agreement without creating a separate legal entity. So a joint venture governed by the general contract law of Civil Code of Azerbaijan Civil Code provisions. There is no separate legal personality. Each party remains independently liable. Joint venture is a common and in construction, oil and gas and infrastructure projects. Tax application and profits are allocated as per an agreement. The joint venture, contractual joint venture, is best for the short-term projects and companies seeking the flexibility without forming a new legal entity. But the most popular joint venture form is an incorporated joint venture form in Azerbaijan. So the incorporated joint venture can also established as a legal entity registered in Azerbaijan, usually as a limited liability company or a joint stock company. So joint venture as a limited liability company, the most common structure of joint ventures in Azerbaijan. The minimum charter capital is not defined by legislation for the LLCs. Liability limited to capital contribution is defined for the joint venture as a LLC, and joint venture as a limited liability company requires state registration and compliance with the tax law. Such form is the best form of long-term cooperation with the partners who want to legally separate entity and limited liability. The joint venture may be under the joint venture may be in the form of establishment of the joint stock company. It's suitable for the large-scale projects required the capital market as access. So the minimum capital requirement for the joint stock companies is 2,000 manats for the closed joint stock companies and 4,000 manats for the open joint stock companies. Shares can be publicly traded or privately held. It depends on the open or closed joint stock company. This form is best for the large business requiring external investment, stock insurance, and capital market involvement. The foreign investor can engage in business partnership or joint venture under the local legislation. Key consideration concludes that the full ownership or partnership, foreign entities can fully own or partner with a local business. Tax benefits, customs, and exemptions are reparations rights apply to the foreign investors in priority sectors as it applied to the for the local and foreign investors have equal rights in the investments. And some sectors for telecommunication, banking, oil and gas, and etc. Requires additional regulatory proof. It is important. Okay. For the risk mitigation, for the mitigation of the risks in business partnership and joint ventures, you should clearly define capital contribution, governance, and profit sharing, exit strategies, and dispute resolutions. Properly register the entity and comply with the tax, competitions, and licensing laws. Ensure the trademarks, patents, and trade secrets are legally protected in technology-based joint ventures. Consider the arbitration in Baku or international arbitration in for the foreign joint venture disputes. Choosing the right legal structure for the business partnership in Azerbaijan depends on factors such as liability exposure, investment needs, government's preference, and regulatory compliance, of course. Businesses seeking flexibility with a limited liability often for the LLC, while partnership with active managerial roles may prefer general and limited partnerships. Azerbaijan offers multiple business partnership and joint venture structures, allowing the investors to choose a model that the best fit their business objectives and risks tolerance. While the general and limited partnership provides the flexibility, joint ventures offer a more structured approach for a long collaboration. Okay, and the legal and tax due diligence is essential before the forming the partnership or joint venture to ensure the compliance and protect business interests in Azerbaijan law. Okay, talking about the joint venture, we should note the shareholder agreements and its roles in communication between the business partners. So the shareholder agreements are not explicitly regulated under the Azerbaijani corporate law, but are recognized under the general contract law principles outlined in the Civil Code of Azerbaijan. This means that as long as such agreements do not contradict mandatory provisions of the Azerbaijani corporate law or company's charter, article of association, they remain enforceable. For the joint stock companies and the limited liability companies, shareholders' agreements serve as a supplementary governance tool, or provided they align with the Civil Code of Azerbaijan, law of state registration and state register of legal entities, and the company's charter, of course. So let's talk about the key provisions of the shareholder agreement. So the well-drafted shareholder agreement typically included of the following provisions: governance and decisions-making rights, share transfer and exit strategies, divided the policy and capital contribution, protection of minority shareholders, and confidentiality and non-competitive clauses, and the last one, the dispute resolution mechanism. So talking about the governance and decision-making rights, it's about the allocation of voting rights among the shareholders, procedures for the board appointments and removals, reserved the matter requiring anonymous and qualified majority approval. Shared transfer and exit strategy consists of the rights of the first refusal. It requires shareholders to offer shares to existing shareholders before the selling to the third party. Tag-along rights, it protects minority shareholders by allowing them to sell their shares under the same terms as majority shareholders in the third-party sale. Drag-along rights is allow majority shareholders not to force minority shareholders to sell their shares in the event of company sales. And the last one is the locking period. It restricts share sales for a certain period of ensure stability. Dividend policy and capital contribution is the rules of the profit distribution and dividend payments, capital calls and funding obligation for the existing shareholders. So the clause D, the protection of minority shareholders, is a provision ensuring the proportional representation in corporate decisions, veto rights on critical corporate actions such as mergers, acquisitions, or liquidations. Confidentiality and non-competitive clauses specifies the prohibiting shareholders from the disclosing confidential company information, restricting shareholders from engaging in competitive business. And the last one, it's dispute of resolution mechanism, which is very important. It defines that arbitration or mediation clauses to avoid likely litigation, or defines the jurisdiction selection typically favor Azerbaijani courts or international arbitration if the foreign shareholders are involved. So why we need the shareholder agreement in corporate governance? We need it for the reducing corporate disputes by clearly defining the rights, obligations, and dispute resolutions methods. Shareholders agreements help prevent conflict among the shareholders and between the shareholders and management. And we need it for the training the investor confidence for the companies seeking foreign investment or joint ventures, as well a well-structured shareholder agreement ensure clarity on governance and exit strategy, making the company more attractive to investors. And we need the shareholder agreements at last for chasing the business stability. Lock-in provisions and structured decision-making processes provide continuity and predictability, which are crucial for the long-term business planning. Shareholder agreements are considered private contract and are generally enforceable under the Azerbaijani contract law. However, the terms mustn't contradict mandatory corporate laws and company charters. There are some limitations in the shareholders agreement. So please pay attention on the limitation defined for the shareholder agreement. The first one is a conflict with the company's charter. If the provisions of the shareholders agreement contradict the company's charter, the latter prevails. Non-recognition by the third parties. Since the shareholder agreements are private contracts, they do not bind external stakeholders such as regulatory authorities or creditors. The judicial challenge court in the Azerbaijan may refuse to enforce certain provisions if they conflict with the public policy or corporate governance principles. So what is the best practice for the drafting shareholder agreements in Azerbaijan? To ensure legal effectiveness and enforceability, considers the following the best practice: align the agreement with the company's charter, ensure the consistency with the corporate bylaw, as I said before, clearly define dispute resolution methods. Arbitration clause can provide more efficient means resolving the shareholder conflicts. Considers notarization or registration if it's applicable. While not mandatory, notarization can provide additional evidentiary value, but it's not mandatory, as how I said. Regulatory review and updates the agreement. As the business grows, amends the agreement to reflect new realities. So what's the shareholders agreement are the critical tools for corporate governance and risk management in Azerbaijan. While not explicitly regulated, they serve to the supplement statutory frameworks, ensuring the stability, protecting minority shareholders, and mitigating disputes. Given their private contractual nature, careful drafting, alignment with the corporate law, and legal review are essential for the enforceability. Okay, the government structure of the joint venture on whether it's a contractual joint venture, as I said, governed purely by the joint venture agreement without forming a separate legal entity, and equity-based joint venture where the new LLC or joint stock company is created to manage the venture, as I told before. So the contractual joint venture based solely on the agreement between the parties, but doesn't create a separate legal entity. As I said, the key governance features include the management committee, comprising the representative from each joint venture party responsible for the day-by-day operation. Decision-making mechanism, typically structured as an anonymous majority and proportional voting based on the financial contribution or predefined contractual terms. Profit and loss distribution, allocated per the contractual terms, usually proportionate to cost contributions. And the last one, the dispute resolutions. Its arbitration clauses are common, especially in cross-border joint venture. Regarding the equity-based joint venture, when the party establishes a new company, the governance structure follows the corporate rules applicable to LLC or joint stock company under the law of Azerbaijan. The key governance body included the general meetings of the participants or shareholders, board of directors, supervisory board, if applicable, and executive management, CEO, management director, executive board, etc. General meeting of participants or shareholders, supreme decision-making body. It's a supreme decision-making body. It approves strategic decisions, including the change in charter, merge, and or liquidation of the entity. Voting rights are determined by equity stakes. Board of director or supervisory board required for the joint stock company, optional for the LLC. It oversees executive management and protect minority shareholders, and can include independent directors in foreign invested joint ventures. And the executive management handles daily operations and reports to the board if it's applicable. And the executive management powers are defined in the joint venture agreement and company charter. Okay, let's talk about the decision-making rights in joint ventures. There may be unanimous or majority decision-making, veto rights and minority protections, and reserved matters. Okay, the anonymous and majority decisions-making is required for fundamental change such as amending of the joint venture agreement, dissolutions, or significant capital expenditures. Majority vote typically applies to operational decisions and minor strategic matters. Regarding the veto rights and minority protections, the minority shareholders less than the 50% ownership may negotiate veto rights over the key issues such as new investments, business scope change, or executive appointments. Deadlock resolutions, if the joint venture partners have equal stakes, mechanisms such as third-party mediation, arbitration, or pre-agreed exit clauses are included. And the third matters, certain decisions may be decided as reserved matters requiring the enhanced approval their holds. They may be include issuing new shares or altering the shareholding structure, entering into the significant contract or financial obligation, or changing corporate governance structure. For the mitigation of the risk in joint venture governance, we should clearly define the roles and responsibilities, establish the authority of management body and decision-making thresholds, include the deadlock resolution mechanism, avoid the business paralysis by the incorporating mediation, arbitration, or buyout options, protect minority shareholders, ensure the veto rights and proportional board of representations for minority partners, and comply with the Azerbaijan law and regulatory requirements in regulated industrial, especially in regulated industries, oil and gas, and finance. Governance structure and decisions-making rights in Azerbaijani joint ventures depend on the chosen legal form and contractual arrangements. Proper structuring of the management bodies, voting rights, and the dispute resolution mechanism is essential for ensure operational efficiency and legal protection for all parties involved. Joint venture partners should seek legal consultation to draft agreement with align with the Azerbaijani corporate law and international best practice. Joint venture in Azerbaijan serves as a strategic vehicle for the both local and foreign investment to collaborate on commercial projects. However, effective investment protection mechanisms are crucial to safeguarding the capital contributions, intellectual property, management rights, or financial returns. Given Azerbaijan's legal framework and its commitments to the foreign investment protection, joint venture agreement must incorporate specific contractual and legal safeguards to mitigate risk related to the expropriation, governments and disputes, existing strategy, and regulatory compliance. So next one is a key investment protection mechanism in joint venture agreements. Investment protection in Azerbaijan is governed by the Civil Code of Azerbaijan Republic, regulating the corporate and contractual relationship in joint venture. The law of investment activity defines the legal guarantees for local and foreign investors in Azerbaijan, and bilateral investment treaties. Azerbaijan has signed multiple BITs offering protections such as a fair treatment, non-discrimination, and access to the international arbitration. Okay. Capital and assets protection clause is very important in the joint venture agreement, as well as drafted joint venture agreement must clearly define equity contribution, the form of capital contributions, cash, property, technology, IP, or the valuation. Ownership rights, percentages of the ownership, and conditions for the capital dilutions, if any. Restriction on the assets transfers. Limitation of unilateral disposal of this joint venture assets without the partner consent. And the last, the intellectual property protection defines the rights over the patents, trademarks, and the proprietary technology brought into the joint venture. Management and control safeguards. Control over the decision making is a key protection mechanism. Participatory for the minority investments to prevent the potential abuse by the majority shareholders. Joint venture agreements should include board representation. Minority partners should have proportional board seats or veto rights on the key decisions. Reserved matters, certain strategic decisions, major capital, for example, major capital expenditures, sale of the assets, and dividend distribution should require the unanimous or supermajority approval. The management appoint rights is a protection of the ability to appoint key executive or veto unfavorable appointments. Investor must ensure a mechanism that guarantee or their ability to recover investment, receive profits. So we need to dividend policy, clearly define how and when the profit will be distributed. Repatriation of profits, that was also very important for the foreign investors to ensure compliance with Azerbaijani foreign exchange law and international agreements allowing the free profit repatriation. And if the partner provides debt financing and the joint venture agreement should include priority repayment rights and protection against unauthorized financial liability. To safeguard against the forced exit of the devaluation of investment, a joint venture agreement should provide the right of the first refusal, tag along the drag along rights, put and call options, deadlock resolutions mechanism. And very, very important things, define the dispute resolution and legal recourse. Choice law and jurisdictions clearly defined Azerbaijani law or optional for neutral and international law is permitted. Arbitration clauses. Many foreign investors prefer arbitration under the ICSID or the ICC rather than Azerbaijani courts. Governing language is international parties for involved ensures that the official English version of the contract is legally recognized. The stabilization clause ensures that the future change in Azerbaijani laws do not absurdly affect investor rights. And under the Azerbaijani investment law and BITs, investors are protected from the unlawful exploration without fair compensations. So, in a conclusion, we may say that a well-constructed joint venture agreement in Azerbaijan should incorporate robust investment protection mechanism to safeguard capital contributions, financial interests, and governance rights. Given Azerbaijan's legal framework and international investment protections, investors should negotiate contractual safeguards to mitigate the risks such as shareholders' dispute, profit repatriation barriers, and government interventions. To ensure of comprehensive protection, it's advisable to seek legal counsel with expertise in Azerbaijani corporate and investment law when the drafting the joint venture agreement. Okay, there's a next slide. It's about capital contribution clause, profit sharing and capital contribution clauses in joint venture agreement. So the capital contribution clause should explicitly state the total amount of initial capital required for the joint venture, the form of contribution, cash, assets, technology, etc., the valuation of method of non-cash contribution, for example, fair market evaluation, third-party assessment, or others, timing and schedule for capital injection. And to address the future financial needs, joint venture agreements should include capital call provisions, whether the additional capital contribution are mandatory or voluntary. The process for requesting capital injections and the consequence of the parties' failure to contribute additional capital, duration of equity. Okay. This next slide says restrictions of withdrawal of the capital. Protect financial stability, capital withdrawal limitations should be established. Prohibition on literal withdrawal of contributed capital. Allowable contribution for the capital reduction upon the joint venture termination. For example, no party shall withdraw its capital contribution from the joint venture without the written consent of all partners and compliance with Azerbaijani corporate regulations. Okay. The profit sharing clauses should clearly define the profit sharing clauses should clearly outline the percentages of profits allocated to each party, whether profit sharing is fixed or based on the contribution or performance, and whether the profits are invested or distributed. For example, net profit of the joint venture shall be distributed quarterly in accordance with the following proportions: partner A 60%, partner B 40%. Such distribution shall occur within 15 days following the financial statement approval. It's like an example of what we said, what we talk about. Okay, it's very important that distribution timing and tax considerations. The profit distributions should comply with Azerbaijani tax law, and withholding tax on profit repatriation for the foreign investment must be considered on too also. The retained earning and reinvestment provisions. It's about to support business growth. Joint venture agreement may require that the portion of profits and reinvest before the distribution. For example, the joint venture shall retain 30% of net profits annually as a reinvestment fund. The remaining 70% shall be distributed to the partners unless otherwise agreed. And then in addition to profits, the joint venture agreement must address loss allocations, whether the losses are borne proportionally to ownership, whether additional capital call will be triggered in case of sustained losses. For example, losses shall be borne with the parties in proportion to their ownership interests. No partner shall be liable beyond its contributed capital unless the additional funding obligation is explicitly agreed upon. Properly drafted capital contribution and profit sharing clauses are essentially for ensuring financial stability and preventing disputes in a joint venture in Azerbaijan. These clauses should be aligned with the Azerbaijan corporate and investment laws, while incorporating mechanisms that protect both local and foreign investors. Okay, voluntary buyout by the joint venture partners. So one of the most common existing mechanisms is a buyout where the existing partner sells the ownership stake and remaining the partners. The key consideration of this is the valuation method, fair market valuable independent appraisal, or payment terms, lump sum or installment payments, regulatory approvals, if they requires for the foreign investors. For example, the withdrawing partner must first offer the share to the remaining partners at a fair market value determined by the independent auditor. If no agreement is reached within 60 days, the withdrawal parties may seek third-party buyers under the same terms. Okay, and the joint venture partner may sell its shares to the external party if the joint venture agreement allows for the third party's transfers. So key consideration in this is right of the first refusal. Remaining the partner should have an option to purchase the existing partner's stake before it's sold to outsider. Pre-approval requirements. Some joint ventures requires the partners to regulatory approval before the sale. An impact on the joint venture operations. A new partner may change the management or business model. And a joint venture may be dissolved and liquidated if the joint venture terms expired without renewal. Deadlock occurs, making operations unenforceable, and financial difficulties or insolvency arise. And debt settlement before the assets distribution. For example, Upon the dissolutions, the joint venture remaining assets shall be liquidated, and the proceeds shall be distributed among the partners in proportion to their ownership shares after the setting out the standing liability. And the last point, the arbitration or dispute triggered. If the joint venture partners cannot agree with the exit method, dispute resolution mechanism may be determined in the process. For example, in the event of the unresolved dispute over the exit terms, the matter shall be referred to the Azerbaijan International Commercial Arbitration Center, and the decision shall be binding on all of the parties. So, to protect financial interests, partners should be incorporated. Valuation method to be ensure fair pricing of shares. Non-competed clauses to prevent the existing partners from the competing directly with the joint venture. Confidentiality obligations restricting disclosure of the business information post-exit. And the last one, the tax-efficient exit structure to minimize capital gains and repatriation tax. So an effective exit strategy is essential to ensuring the smooth or legally complaint the departure from the joint venture in Azerbaijan. The joint venture agreement should clearly define exit rights and obligations to prevent disputes and safeguard investment. Okay, we finished, dear participants, we finished our webinar. And if you have any questions regarding the subjects, regarding the topics, feel free to ask now.
Thank you, Emil, so much. And please, everyone, if you have any questions, you can just open your mic or write in the chat. Now it's a good time for that.
Okay. Hope it's not very boring, because it's a lot of legal terms, legal conditions in this webinar. But it's very important to start the business in Azerbaijan to understand and realize the local regulatory requirements.
No, I don't think it's boring at all, and very important and interesting topic. If you are now thinking about questions, I can just shortly tell you about the future. So the next webinar will be held on 20th of May, and the topic is, as Emil previously told, is legal protection of intellectual property in Azerbaijan. We will send marketing material and information soon about this, but 20th of May and 9 a.m. Finnish, Estonian, Latvian time is that webinar. And you can also send questions to us or straight to Emil, and we will get back to you on this. And this webinar will be posted on our website, and we will share the link to you afterwards, and this material will be sent also after this. So Emily, it seems that you were very thorough. No questions, I think, at the moment. If there are no questions at the moment, so thank you all. Thank you, Emil, for a very nice and thorough presentation, and thank you everyone for participating, and thank you for your time. And let's keep in touch, and hope to see you in our next webinar, and maybe in our next trade mission to Baku also. Thank you, everyone. Have a nice week.
Thank you very much. Thank you very much. Bye.